Hi, everyone. We'll be starting shortly at about 12:02 for the panel. Hi, everybody. Welcome to Antitrust Roundup 2021. What can we expect from competition policy in 2022? I'm Kier. I'll be moderating the event, and I'll actually be introducing our panelists really shortly. For this panel, we just kind of wanted to gather up some of the best experts we thought on the subject and bring them together to discuss, well, what happened in 2021, what antitrust policies got pushed, what legislative proposals are still on the table that we're looking at in 2022, and what that means for you, me, and our wallets. Our first panelist is Sam Bowman. He is the Director of Competition Policy at the International Center for Law and Economics. He's also the former Executive Director of the Adam Smith Institute and currently an editor at Works in Progress. His works on antitrust and competition can be found in the Financial Times, The Telegraph, Guardian, City AM, and more. Mark Jamieson is our second panelist. He's a non-resident senior fellow at AEI, where he works on how technology affects the economy and on telecom and the FCC. He's concurrently the director and Gunter professor of the Public Utility Research Center at the University of Florida's Warrington College of Business. He's written 3 books, and his writing has also appeared in Real Clear Markets and the Journal for Competition Law and Economics. James Czerniawski is the senior policy analyst at Americans for Prosperity. He recently authored a chapter in Eyes to the Sky, a book on drones from the Cato Institute. He writes on consumer data privacy, cybersecurity, tech and innovation, and has been published all across America. And finally, we've got Tom Hebert. He's a federal affairs manager at ATR and the executive director of the Open Competition Center. The Open Competition Center and Tom advocate for a rule of law and consumer-based approach to antitrust regulation. Thank you all so much for joining us, and I can't wait to hear your thoughts. So kind of to start us off, Sam, I wanted to ask you, why should average people care about antitrust law? Like, how does it affect us every day? And why isn't it in the news so much?
Well, I would say the reason you should care about antitrust is because you should care about competition. And to make things more complicated, the reason you should care about competition is because you should care about innovation. And really, it's new ideas, not just new inventions like the iPhone, but also new business models like Uber and Airbnb are the things that raise our living standards and mean that we can buy more things, and means that we get paid more, and means that things we can buy are of higher quality than before. And we tend to think that the market that generates that kind of outcome and that generates that kind of behavior is one where businesses can enter freely and can do more or less what they want without being frustrated, either by the state or, in certain cases, by other businesses. And the antitrust laws are a very imperfect attempt to preserve the most competitive market possible. I think that we should care about the antitrust laws then for 2 reasons. One, because sometimes they can make markets more competitive by stopping businesses from, for example, forming cartels together, or from engaging in certain conduct that prevents other businesses from being able to compete. But also we should care about the antitrust laws because they often fail and because they often frustrate competition and frustrate innovative businesses' attempts to do new things and do them in better ways. So sometimes they need to be protected and sometimes they need to be promoted, but other times we need to be aware of when they're being misused. And I think the best analogy might be the criminal justice system, where of course we need a criminal justice system, and of course sometimes we need to prosecute people and sometimes put them in jail. But we also need to be alert to times when the criminal justice system isn't working and is prosecuting conduct that is very good and prosecuting things that are benign and that we shouldn't be punishing people for, and making people's lives worse and making society worse by being over enforcing the rules. So it's a very, very it's a two-sided blade or two-sided sword, two-edged sword. But the ultimate goal is because competition and innovation improve living standards. And really, that's all that we should care about at all from the economy.
From that, I've heard nothing really about why antitrust and tech are specifically intertwined. It sounds like antitrust isn't even really about tech, but really about consumers. James, could you explain why the current antitrust atmosphere is then so focused on tech versus the consumer-focused perspective that Sam was talking about earlier?
That's a great question, Kerr. And a lot of the reason why I think we're seeing the focus is on these technology companies is in large part because their interaction with consumers is radically different than a lot of the other industries that we know and experience that were in the analog era. So as our economy has become increasingly digitized and focused on services economies, these technology companies have done an excellent job in a lot of ways of integrating those different facets into consumers' everyday lives. And they're wildly successful at this, to the tune of hundreds of billions of dollars, trillions of dollars in valuation for some of these companies. And when you get to that level of success, it is definitely a little difficult to avoid not having a target painted on your back. So technology companies certainly find themselves in this unenviable position of being the target of scrutiny from either side of the political aisle when looking at certain issues that arise in competition concerns that we've seen come out of Washington over the past several years.
That's really interesting. In 2021 specifically, we saw competition policy narrowed down into these legislative proposals that almost seem to strike at tech specifically. Mark or Tom, do you want to explain how we've seen 2021 attack competition policy in these legislative proposals?
I'll let Tom go first.
Well, I think it's kind of a good news, bad news situation. The good news is none of these horrible ideas have become law. But the bad news is that there's a bunch of live ammunition out there that we have to be mindful of. There was a slate of 6 bills marked up by the House Judiciary Committee in June in a marathon 29-hour markup. After an 18-month, I believe, investigation into the business practices of 4 companies, they kind of decided to throw a dart at a board and then draw a bullseye around it. So these bills focus on companies with a market cap or net sales of $600 billion and 50 million monthly users. And what it does essentially is gives the Biden administration sweeping new power to regulate these companies. The left may say to conservatives they care about, stopping censorship or their concerns, but in reality, it's just a power grab for the government. And, all these bills are live ammunition on the House floor. The Senate side, we've got 2 bills that have been recently introduced. One, the American Innovation and Choice Online Act. That's the one that bans so-called self-preferencing, which is when a platform company promotes a generic product next to a name brand product. Well, if you've ever been to CVS or any retailer, they do that all the time. So it makes no sense to ban a platform company from doing something a brick and mortar retailer can do. And secondly, you've got the Platform Competition Opportunity Act by Klobuchar and Tom Cotton. The interesting thing about that bill is that, all the other antitrust bills set this sort of covered platform definition, where if you're a company that dares to grow above this government set threshold, you get whacked with all these new regulations, right? The Klobuchar-Cotton bill says, okay, at the time of enactment, the companies that hit this threshold get whacked by these regulations and nobody that comes after it. So it's interesting when you look at the fastest growing e-commerce retailers, Walmart and Target, right? Walmart's headquartered in Arkansas. and Target's headquartered in Minnesota. So while I love both of these companies, we all shop there, right? This really is more about crony capitalism than it is protecting the consumer.
Now, let me just add to that a little bit. He's exactly right on what's going on, the different legislation that's out there. Let me talk about where this kind of comes from and where it might end up going in terms of the effects on consumers and businesses. This focus on tech started a few years ago. And I won't try to project what was in people's minds as they jumped into it, but there was a large investigation by the House Judiciary Committee. Spent several years looking into the tech industry. And there was a large majority staff report that came out from those investigations. A couple of curious things about the report. One is that its primary resources were newspaper articles and memos that they obtained from companies. And so it takes on the flavor of kind of gotcha stuff, because you know that's what ends up in newspapers, the kind of got you. You're reading somebody else's mail and it misses all the context. So just like we had with Microsoft many years ago and a lot of other investigations, when you hear people talking within a business, they speak in aggressive terms, and now that all becomes public and it gets misinterpreted and misunderstood. So that was considered evidence. The other part is what they did not consider evidence. By one of my colleagues' counts, Danny Sokol out at the University of Southern California, there's over 260 academic articles, peer-reviewed articles on competition between all these platforms. How many were cited by these researchers at the House Judiciary Committee? Not one. All they cared about were the memos, the newspaper articles, such as that. So that's a real problem for us. Now let me talk just a little bit then about what can fall out. I've forgotten the name of the young woman I was reading about a couple of weeks ago. I'll just call her Pamela, but I don't know if that was her real name. It was just a case study in someone using one of these platforms in a sense that would now become illegal under some of these laws. She, back in 2017, lived in a trailer court, was a waitress. She discovered that she could get things from yard sales and resell them on eBay and make a little money. Then someone said, what you really ought to do is look at what Amazon offers, because Amazon has all these tools that can help you grow a business. They can really market well to a lot of people. And she watched YouTube videos and she said, yeah, this really works for me. Amazon has this great platform. It has this great platform because it sells its own stuff on this platform. Otherwise, it would look like eBay. The past 2 years, she's made $4 million. That's a tremendous change in someone's life. It's not just the consumers, it's all the business opportunities that evaporate if we try to turn Amazon into eBay, or we try to turn Google into Bing or Yahoo. Not that Bing and Yahoo are bad, they're just not as well regarded as Google in people's searches.
To add to what Mark said about the House Judiciary report, my favorite anecdote or my favorite thing about it is that it makes a really big thing of the fact that it says startup formation activity has fallen in recent years. And it bases this, recent years, on a piece of data from 2011, which is both neither recent years and also immediately following the financial crisis, when perhaps it isn't big tech activity that was the cause of startup formation falling. And in fact, since 2011, startup formation has increased really significantly. So even by the standards of the report itself, if you used up-to-date data and if you use up-to-date evidence rather than the 10-year-old data that it uses, the case for the things that it's arguing for is very, very weak.
You both have brought up the fact that it seems that the Hill and their expeditions have forgotten competition academia in some regard when discussing how to move forward on competition policy. If you were to describe the Hill's movement towards new antitrust, where are we heading if they're not looking at academics or at recent data?
Well, if I could go first, Mark, I think what's interesting is that until very recently, the big divide in antitrust wasn't really between people who objected to what's called the consumer welfare standard it was between people who had a different view about how to promote consumer welfare. So on one side, you had relatively non-interventionist people, I count myself among them, and on the other side, you had people who thought that actually businesses do all sorts of things that frustrate competition, and we need to stop them from doing that, and that will improve consumer welfare. And so we could all agree about the end goal. It was the kind of means to get there that there was some disagreement on. What's interesting is that in the last few years, it's been this meteoric rise of what's called the neo-Brandesian school. And they've really eclipsed the kind of mainstream pro-interventionist side, who are much more, in terms of academic and kind of credentials, much more well-established. But the neo-Brandesians argue that consumer welfare is a completely broken standard because it ignores both lots of other forms of welfare that we should care about. So, for example, worker welfare or the environment or things like that. But it also, they think, neglects, and I think they would probably say this is the most important thing, the corporate influence over politics and the power of big business to influence the democratic process. And so the neo-Brandesians, who've become, since the Biden administration, really the ones in power, Lina Khan is the leading example, but Tim Wu, I think, would fall into this school as well. He's at the White House. Believe that there's a kind of non-economic challenge that antitrust has to answer by preventing businesses from getting big enough that they can have influence over the democratic system. Now, I think that's empirically mistaken. I think it's a bad approach to antitrust. I think there are lots and lots of problems with it. But what I think is really striking is that the kind of pro-intervention, academic and well-published kind of mainstream that was pro-interventionist has really been left in the dust here. And I think we're still trying to assess what that means, whether those people will throw their lot in with the neo-Brandesians because they're pro-intervention and they think, we may share different goals, but we share similar means, or whether those people, or some of them at least, will decide that they would in fact prefer to stick to the methods and the goals of antitrust over the last few decades, and that the neo-Brandesian kind of almost revolutionary approach is really not one that they want to throw their truck in with.
And if I could just add to that, essentially, I'll add two things. One is kind of where this idea, the neo-Brandesians are trying to take us, and then also where they would indeed take us. So where they're trying to take us is back to where we were 1950s, 40s, 30s, and such with antitrust. And it's before economists were asked to study these particular issues. So in 1969, George Stigler was asked to lead by the administration, asked to lead an investigation of how antitrust was going. And what he found that things were really sloppy. A lot of it was ad hominem arguments. If attorneys didn't like somebody, they filed lawsuits against them. There's a lot of inconsistency amongst decisions. Companies trying to conduct their businesses didn't know what the rules would be. And consumers were completely out. Nobody cared what happened to consumers with any of the actions that were going on. And so that started a movement of bringing economic analysis into it. And then it really hit home. You get into the 1980s. That's when the consumer welfare standard, I won't bother going into the history, really started coming in and saying economy is about consumers. And so when we think about competition, let's focus on consumers. The neo-Brandesians want to say all that history of finding bad analyses, bad cases, and trying to improve them is just wrong. We want to go back to the days where actually there's a lot of politics in antitrust. And that takes me to the second point then. Where they really take us is to a space where the government is very interventionist in an economy. And if you want to really damage a democracy, make all the businesses very dependent upon what government does, because that's where they'll spend their time, that's where they'll spend their money. They know the competition is in the political arena, not in the marketplace for consumers. It gives us corruption, it gives us huge businesses, as opposed to lots of entry and competition. It doesn't go well for consumers.
When we're talking about the neo-Brandesians and just the fact that it seems to be that the federal legislative proposals are following in that regard, Tom or James, have we also been seeing that in the States? Like, is antitrust reform now just becoming a term to describe a whack-a-mole style of legislation that takes what the neo-Brandesians have brought and just decides to hammer it wherever we can, if that's a state, the nation, or even another nation?
Yeah, I think that you're certainly seeing movement on the state level, looking to go and address these issues in one way or another. It doesn't necessarily always tee up to antitrust legislation per se, though on the state level, the most notable case where we've seen state legislation aimed at explicitly trying to reform their state antitrust laws is in the state of New York, my home state. And when you're going down that route, you're just, again, you're throwing out a lot of the economic history that Mark was alluding to before that we've seen. We know what it was like before we had the consumer welfare standard. And when we're placing this emphasis away from competition in the manner that focuses on the consumer, we really do stand to go and have significant economic harm, not just to the businesses, but ultimately to the consumer. But there's just such an animus towards wanting to go and focus on these technology companies that I think state legislators or even federal legislators might not understand the encapsulation that it's much broader than just these technology companies. Like, just messing with antitrust laws does not just mess with big technology companies, but there are a lot of other competitors that are out there in other industries that are rapidly growing, as we've talked about earlier, that would equally suffer under this kind of significant and radical change to antitrust regimes.
I kind of want to then bring it to you, Tom, and kind of have you explain just a little bit.
So if the regulatory approach,
it's never a dull day when your AirPods from downstairs decide to become your default speakers.
Big tech strikes again.
I kind of want you to explain, Tom, why regulatory approaches could lead to poor outcomes. It sounds like obviously they forget consumers, but what else are we forgetting in these current discussions? Like, are we forgetting to define markets, or are we just hammering something that doesn't need to be hammered?
Right. I mean, as a fellow New Yorker, I'll briefly touch on the antitrust bill there. I mean, instead of the consumer welfare standard, which has been the lodestar of antitrust law for almost 50 years, was developed through decades of consensus. The New York antitrust law focuses on a European style abusive dominance standard, which has absolutely no precedent in US law. And, it would apply to all companies that do business in New York. You don't have to be headquartered there, but if you transact in New York, which, I mean, given that most businesses are online these days, doesn't really narrow it down. New York is setting a de facto standard for the entire country. And as far as the regulatory aspect is concerned, I think conservatives need to look at it as what new powers are we giving to the government to reshape the economy. Antitrust is such an awesome tool. And I mean that in the old sense of the word, which is, giving the government the power to break something up is a huge, huge tool. And we really need to be mindful of when we use that tool. And I think that this animus against technology companies has sort of blinded conservatives to the idea that giving the government power is not really ever a good outcome for consumers and for the economy. The danger with some of the House bills, at least, is that the Access Act sets up secret kind of technical committees designed to monitor the activities of the companies that the package targets. So conservatives used to be worried about regulatory capture. If you're a conservative and you don't like the way that Silicon Valley deals with content moderation, imagine if those companies have to go to the government to ask for permission to engage in routine business activity like merging or acquiring. It's really sets up a dangerous situation, at least for conservatives, because essentially the government could turn around and say, okay, you need to do more of the things that conservatives hate, especially with this administration, because you've seen sort of a constellation of all fronts. You've got Tim at the White House, you've got Cantor at the DOJ, you've got Lena Khan at the FTC, who has wasted no time smashing bipartisan norms. It's really kind of a confluence of events, and conservatives just really need to focus on, what new powers are we giving to the government, and how will they impact consumers at large.
I kind of even want to bring that out a little bit more and direct it to you, Sam. It's not just Khan at the FTC or Wu at the White House. It's Vestager in the EU and like the Digital Markets Unit and Competitive Market Authority in the UK. How has this movement for what I'm going to call aggressive antitrust, because I can't pronounce a lot of those words continuously, how has it kind of become global in nature? Are we forgetting lessons that we should have maybe learned from the EU in, say, like the 2000s and the 2010s? Why is this such a global phenomenon?
I think the route, one other country that's worth bearing in mind is China, which interestingly has taken steps that are quite similar to steps that have been proposed in Europe and the US, although I think for much more sinister reasons. I don't mean to compare any of the motivations. But what I think is a common thread in all of this is a deep concern about corporate power and a deep concern about the unequal economic influence that digital platforms in particular appear to have. I am not concerned about the influence that digital platforms have over the sellers and the consumers that use their platforms, because fundamentally, I am convinced that those digital platforms do compete with one another and do compete, most importantly, with potential non-existent competitors in the future. So that kind of contestability and that ability of new companies to come in, and the fact that I am convinced that if a new superior search engine, for example, did come into the market, and it was clearly better than Google, I think it would be able to erode Google's market share and become the new dominant platform. And what I think that we get, if that's true, is something that's very rare in regulation, really, which is competition between regulators. I think it can be quite helpful to think of digital platforms as regulators of their own markets. And unlike most regulation, where we don't really have an option to opt out and where there's very little kind of learning process, because just by its nature, regulation on a country level has to apply to everybody. When it comes to digital platforms, provided there is this competition that I think does exist, consumers can pick and choose, and consumers can vote with their feet and vote with their wallets to pick the so-called regulation or regulator that works best for them. So Mark used what I think is a really great example of eBay versus Amazon. I think it's impossible to know kind of a priori whether the eBay very neutral, very hands-off, very open model is better or worse than the Amazon less neutral, more interventionist, more regulatory in many ways model. And it's only by really trial and error. It's only by sellers and buyers using these different platforms and seeing which ones work best for them that we can figure out which approach is best. So I think that works really well, and I'm very, very pleased with the outcomes that we've got. I don't always agree. I sometimes wish Amazon had slightly different policies. I sometimes wish Google did things differently, Facebook did things differently. But I'm comfortable that the discovery process that competition involves has helped us get to better kind of rules for the internet than we would get if, for example, we had to design them from the ground up. What I think we see in every jurisdiction is, first of all, a deep concern that the rules are not being set by the state, but instead being set by private companies. And that's considered to be perhaps threatening to the state, explicitly so in China, implicitly so in perhaps Europe and the United States. And also a belief that those rules are wrong, that the actual object of those rules is wrong, and disadvantages other companies in a way that's not okay. And to summarize, when I talked earlier about competition as being about businesses being able to compete, that's a really nebulous phrase. That really is a very, very difficult concept to pin down, because ultimately, if you're concerned too much about the welfare of businesses, you lose sight of the thing that we actually care about, which is the welfare of people who are buying things from those businesses. And you get results like condemning price cuts that are sustained and sustainable because they disadvantage other businesses. And you get things like the European Digital Markets Act, where a lot of conduct is prohibited, not because it's considered to be bad for innovation or because it's considered to be bad for consumers, but because it's bad for the other parties that use the platform, the other sellers that use the platform. So I think ultimately it is a really deep and fundamental concern about where power lies. I am pleased, actually, that power does not lie entirely with the state and entirely with the regulator. And I think that decision-making like that is much, much better exercised when we can vote with our feet and go to different decision makers and kind of pick and choose like that. But if you find that threatening, and if you think that that's a challenge to democracy, I can totally see why you would want to take these companies down. I just think you're very misguided about what that's going to actually look like.
Mark, do you want to tune in?
Yes, we've talked a lot about breaking up companies. We've talked a lot about corporate power and influence in government. And one of the case studies that people in the new Brandeising Brandeisian group like to point out is we successfully broke up AT&T. So let me tell you the story about AT&T. AT&T needed to be broken up because it was a government-protected monopoly. It became a government-protected monopoly back in the 1920s or so. It really wasn't AT&T's intent to become a monopoly. It was actually approached by the government, said, wouldn't it be cool if you were a monopoly? And they said, yeah, I guess so, and took it on. And one of the things that they did to become a monopoly was not just get government protection, but they made sure that all the telephone networks in the United States interconnected seamlessly. So there was no incentive to compete anymore. Now notice the mirror of that's going on in some of our legislation, where like these platforms do, all interconnect and all share resources, and that kills competition, doesn't promote competition. Now roll the clock forward. I'll jump into the 1970s. That's when we first started seeing someone wanting to compete with AT&T in terms of networking. Regulated monopoly, protected by regulators. It took us over 20 years to finally break down all the barriers, primarily government barriers, to competition. We had to break up the company, and we did indeed break up the company, but that's not what created the competition. What really created the competition was wireless. The great innovations in wireless technologies really broke the monopoly more than did the breaking up of AT&T by the regulators, or by the antitrust courts anyway. So what do we learn from that? Well, we learned that if you step in and start having a lot of government intervention, costs go up for companies. And that's the cost of being regulated. And so you get less competition because the small companies can't afford that. We get this great uniformity, which also is, in a digital world, means it's really tough to compete, so people don't do that. Innovation really slows down. And you get a great concentration of power. One of the stories I heard that I really liked was back when the government was debating whether or not AT&T should be broken up. Timothy Worth was the head of one of the House committees, as I recall. He was holding a hearing on AT&T and its anti-competitive conduct. And partway through the hearing, he just stopped. He said, I'd like to know, the room is packed with people all wearing gray and blue suits. He said, I'd just like to know, everyone in this room that is employed by AT&T, would you please stand up? Everyone stood up. That's what happens when you have the government and industry get very close together. The industry puts a lot of resources and a lot of time into influencing government.
Tom, it looks like you also want to jump in.
Yeah, just quickly, I mean, it's worth highlighting that really the only monopolies that last for any long period of time are those protected and granted by the government. I mean, I'm just old enough to remember using Internet Explorer to log onto my computer, reading my news on MSN, messaging my friends on AIM, going on MySpace. Like, all of these monopolies of yesterday are gone now. And, it's sort of that punks in the garage theory of competition, right? No matter who looks big and powerful today, you're always going to have people coming in tomorrow. And the only real barriers to entry come from the government, not other companies.
Just for the audience, we'll also be having a Q&A at the end and during the conversation. If you're on YouTube, feel free to add it in the chat, and then Zoom on the Zoom Q&A panel. I kind of want to move into getting all of your thoughts at once on a couple of different things as we're rounding up 2021. I mean, it's almost December, though the Christmas music seems to think it is December, which means that legislatively everywhere we work, 2022 is now top of mind. Kind of starting with you, James, what do you predict we'll see in 2022? Are these proposals going to translate over? I mean, the answer might probably be yes, but what do you predict is going to happen?
It's a great question. And if I had a seeing, fall into the future, I would definitely probably have a lot more money in my pocket. But, it'll be interesting to see what happens with this legislation. Obviously, there's an appetite, I think, for Congress to want to go and do something. What that looks like, whether it's the American Choice and Innovation Online Act or one of these other ones that were passed out of Judiciary, we'll have to go and see how all that looks. To me, all the same, I think that it would be an absolute shame, only insofar as that I think that the focus is being inappropriately put on antitrust when in actuality there might be other things that might be causing some of the concerns that legislators may have. So it's like, For example, a lot of my work in Utah, we were looking at some of the consolidation in like legal firms, and there's not necessarily a lot of competition there, and it makes it very expensive for people to get access to the legal system. And by simply going and having a more flexible regulatory environment there, run through the Supreme Court with a sandbox program, all of a sudden you have people getting access to those goods, and you're alleviating some of that pressure that people are looking at. Is that an antitrust problem? No, that was just something that was on the books. And it might be worthwhile for legislators to look at other things that might be driving the root causes, as the popular phrase seems to be with the administration, for these problems that we're seeing in the marketplaces, or that legislators are at least thinking are there, rather than just going for the radical fundamental change to antitrust laws. But then when it comes to the legislation, we'll see. It'll be a very interesting time in 2022.
Sam, are you hoping that maybe we'll be doing something differently in competition policy in 2022? Is there something that might just radically change?
Let me be very conservative first and then be very ambitious. My conservative hope is that there is some delay to the proposals in the United States for long enough that Americans and the rest of the world can see the consequences of the Digital Markets Act in Europe. Because I think there's often a sort of ambition and competition among competition regulators and legislators, this desire to be first, because you get a lot of professional prestige for being first. And the UK's competition authority is really bad for this. I mean, they're great people, but they really, really love being first. And, it makes them look good when they go to international competition conferences. They get to say that they're leading the way, and you can understand why they might want that. But as somebody who has to live under a competition regime, I would like to be last, because I would like to learn from the mistakes that other countries have made. And I would like to adopt whatever has worked well and reject what has not worked well. And I think a really good example of that is the Digital Markets Act, which explicitly prohibits a lot of conduct that, in my opinion, is very good. And I think, in fact, many people will find that in practice is integral to the way platforms work, or at least the way they want them to work. So what we may see, if I'm being kind of conservative, is to see the effects of the Digital Markets Act, or begin to understand the effects of the Digital Markets Act in practice. I don't know if it will actually come into effect in 2022, and be able to see what that actually means for ordinary people in the United States. And hopefully, I think, see that that's not necessarily the way they want to go. My ambitious and intellectual desire, really briefly, is that people will start to differentiate between antitrust and competition. And you did ask me about competition, so you already made me happy. And to understand that competition is a much bigger thing than just antitrust. It's a much bigger thing than just penalizing companies for certain forms of conduct. And once we start to understand that, for example, startup formation is just as determined by access to talent from abroad via immigration policy, and access to talent from within via housing policy and zoning policy, that we can actually pull on many more levers to increase innovation and increase competition than most people who engage in competition and antitrust policy debates realize. That's my super ambitious goal, that we can take a much more broad and kind of holistic view of what it is that drives competition forward. But I think it might be more than 1 year before that starts to happen.
Tom, I want to ask the same question to you, seeing as you're down on state work most of the time.
Yeah, I mean, I think that we just generally have to hope that none of this stuff goes anywhere. I mean, look, it's very clear that at least the House Judiciary package is not ready for prime time. I mean, given that the markup was 29 hours and spanned 2 days, you've got Steny Hoyer coming out and saying that these bills aren't even close to being ready for the House floor. I mean, there's some serious problems with the Senate bills too. But as far as doing things differently, I think Sam is exactly right. I mean, we need to learn from the mistakes of other countries, but I think we also need to take a step back and really look at what problems are we trying to solve, and how can we get there. And I don't think that any of the concerns that lawmakers have will be solved by these bills. I mean, looking at what families care about now, I mean, with inflation alone, the price of everyday household, goods and services are skyrocketing. And I don't really think the answer to that is, hey, let's ban Amazon from selling Amazon basics, right? I mean, I'm pretty sure the only way my dad knows how to get to YouTube is by searching it in the Google search bar. I mean, these bills would ban that too. I mean, your new iPhone would be useless out of the box because Apple could no longer pre-install apps. I mean, for us, you know, that are kind of engaging in this space, I think between now and then, it's worth pointing out that, hey, these bills have unintended consequences. And I don't think any of this is what consumers are asking, especially right after, you know, we've gone through this horrible pandemic.
Kind of building off of that, it sounds like there might just be almost a lack of understanding from people who aren't in this world on what we say sometimes. And sometimes we use terms like antitrust or competition policy or the phrase break up big tech as if it means something a lot larger than what it really does. Mark, are there any other like competition policy related or even antitrust law related issues you think we're having problems with explaining to the public or to policymakers that we'd all benefit from a better understanding of when we're looking forward to new proposals and discussing things like the House Judiciary package or Klobuchar's new bill?
Yeah, I do think we have difficulties with that. And you know, people like me in particular, I'm an academic, which means that I can only talk to a really narrow group of people with any competence. And then I'm an economist, which is even worse. Yeah, so it gets really small. I learned really early in my career, I used to be a utility regulator, that if I wanted to communicate clearly, I had to think about one of my relatives who had never finished high school. And that's who I needed to be able to explain things to. It's really hard to, but we do need to make it very relevant to them. So that's why I tried to give the story of again, I forgot her name, of Pamela's, because it's very easy to understand. You know, the doors were open because of what was there. So I do think that we struggle, and we have to then give examples. My parents, I'm 65 years old. My parents still don't know what I do for a living. It's just kind of off the radar for them. So that's really tough. I'd like to go back though, before wrapping that up, to the question about what's going to happen in 2022. And I think it boils down to the economics of elections and the economics of political careers after people leave office. I had a friend in Congress back many years ago, and I was talking with him about what was going to happen with particular pieces of legislation. He said, "Oh, nothing's going to happen." I said, "Well, why is that?" And he said, "Because as long as that legislation is out there, it rakes in campaign dollars." And so that's part of what we're seeing, I think, is the legislation is there. We've got lots of bills out there because once you introduce a bill and it gets talked about, then you're a player and you get campaign dollars. And that can go on for a few years before something actually happens. And so typically I would say nothing's happening very soon, except that the predictions are the Democrats are going to lose a bunch of seats in 2022. And that changes the calculus quite a bit. If you're concerned that you might lose your seat, that's going to change your incentives. I don't understand political career paths well enough, but that's going to be on their minds. That's going to affect what they will actually try to get through Congress and what they will actually vote for. But I couldn't tell you what that story is going to be.
James, I also want to kind of bring this back to you and ask the same question. What do you think we're not explaining well enough? What do you think we need to be explaining better in 2022 with regards to competition policy?
Yeah, that's a great question. I think, at least from my perspective, one of the big challenges to the story of competition is just showing the different examples that are out there. And also because when we're looking at technology and the way that these companies are interacting with consumers, it's radically shifted even in the past 10 years of how they're doing that and what that looks like. And the way that we're leveraging these platforms is different. So, for example, whereas my grandmother, I love her dearly, she's happy to have a Facebook, but she doesn't in actuality. But like, she'll probably look at YouTube videos. Whereas like my dad, he has Facebook, doesn't use it. He has he looks at YouTube videos all the time or whatever. Then there's me, I'm multi-homing all over the place, and I feel like, there's plenty of options to choose from. And then there's Gen Z that make me feel like I'm a dinosaur already because they're doing that. And then a whole bunch of other things that I don't even possibly know about, because that's just the way it works. And the market here for when we're looking at competition here is actually very dynamic. And we're used to seeing that maybe from like an economic sense in prices, but we're also seeing that now in non-monetary factors in the way of like how we're offering goods and services and what are the benefits of that, right? Like when we're talking about some of these platforms, whether it's, let's say, like, Twitch or Twitter or Facebook, we've also created a large community for people to connect with one another and share with one another in ways that wasn't previously possible, and given a huge amount of power to voiceless, communities that otherwise wouldn't have had the ability to participate in ways that were not possible in the past because of gateway protectors and things like that. So I think that we have to do a better job of showing how competition is emergent in nature, how it is constantly changing, what that looks like, identifying like great stories. So like small businesses on Amazon, for example, that sell, I think I was reading a report that they're making an average of $90,000 a year. That's amazing. That's better than the median income of a lot of states by a long shot. And that's something that should be celebrated, not punished. And we have to do a better job of really bringing out and highlighting those kinds of stories and having small businesses talk about how they're benefiting from it.
I actually want to add in and kind of out of the ballpark, one of the audience questions. So the Federal Trade Commission in its 2022 plan, which sounds great for this call because we're talking about the future of competition policy, they're proposing to drop the words "without unduly burdening legitimate business activity" from their mission statement. A, what does that mean? And B, what does that mean practically? If they're omitting a piece of the statement, okay, but like, how does that impact us via their decision making? It looks like, Sam, you've got a smile on your face, so I feel like you've got opinions.
Well, I think I kind of have to punt it and say, I think it tells us a lot about the mindset of the people who are at the FTC and who are running the FTC, where they think that it's kind of almost a joke to, and the costs of compliance are a joke or kind of not something to think about. I think the practical effect of this actual move would be not very significant. I don't know that this is legally enforceable, but it is a statement of intent. And one thing that we've seen with the FTC so far is that the lean account FTC has been quite willing to use uncertainty as a weapon. Usually we think of uncertainty as being bad for everyone because uncertainty just creates risk without any commensurate benefit to anybody else. It just creates doubt and prevents plans from being made, and that's expensive and costly and so on. I think the FTC is using uncertainty as a weapon by warning companies that it may take action on mergers, for example, long after they've been consummated and long after, until now, they could be challenged. And what it is hoping to do, I think, is to do more than its actual statutory powers allow it to do by using these kinds of threats and using the uncertainty about whether they could, in fact, use these powers in certain ways and how courts would interpret these powers, and really take advantage of the fact that very few businesses want to be the test case. Many businesses will avoid doing something, even if they might prevail in court, because the cost of litigation and the cost of winning that, even if they would win, are so great. So the mission statement change itself possibly doesn't make a huge difference, but it tells us a lot about the mindset of the people who are writing it.
No, that sounds actually quite concerning when you think about it. We've talked a bunch about the same, I've heard the same three statements happen. It's the FTC, the Digital Markets Act, the American the Choice and Online Innovation Act, or the Innovation and Choice Online Act. One's the House, one's the Senate, but both apply, and the House Judiciary package. I'm going to start this off with Tom, but I'll go to each of you for it. What's the biggest proposal or issue within a proposal that concerns you walking into the new year?
I mean, they're all kind of on a sliding scale from bad to worse, as I mentioned earlier. One thing in particular that concerns me, obviously the Jayapal bill. I mean, giving bureaucrats the ability to determine if a company is operating a business line that's a conflict of interest and giving it 2 years to either shut down or sell off that part of the company. That's insane. But the other one that we haven't touched on is this sort of burden shifting idea in the M&A bills, where you're a company and you're sued by the government and you're kind of guilty of anti-competitive conduct until proven innocent. I mean, this is going to create a massive chilling effect on competition, on how businesses operate, and I really think that we're putting, especially as we emerge from the pandemic and try and really stand up and walk again, in a really precarious position as we head into 2022.
James, do you want to go next?
Sure. I think when we're looking at these proposals, I do think that just even the arbitrary notion of giving the power to designate a covered platform status in the legislation is probably one of the most egregious things, only insofar as that it is an extremely powerful tool to give to a regulator. I know Sam basically alluded to the litigation regulation strategy that we've certainly seen regulators take on, and that's very alarming. But what kind of perverse incentives are you going to set up if you're going to allow the FTC and the DOJ to have the power to designate this covered platform status? There are some legitimate concerns that can come out of that, and I think again that it is just not appropriate for this kind of legislation that clearly has so many problems that can impact startup creation, startup acquisition. A lot of startup companies do rely on that ability because they can do so much as they can, but this legislation would truly hurt them. And I think that that's the thing that we're not, really recognizing. That's the worst part about all these bills, is that it's ultimately small entrepreneurs and startups that get harmed in the way of all this legislation because we want to go and take a swing at big tech. I think that's unfortunate.
Yeah, it sounds like offering bureaucracy discretion never seems to succeed properly. Mark, what do you think the biggest legislative issue or issue amongst all of these proposals that we're going to face in 2022 is?
What concerns me most is the unstated assumption that businesses are like Lego blocks, and you can take pieces and reassemble them and you just get cool stuff. And you don't lose anything. You still got all the blocks, they're all still there. That is not the way the world works. If that was the way the world worked, we'd have attorneys build bridges, and we seriously don't do that because that just isn't the way it happens. If you want a good example, think about all the huge, amazing tech innovations that come out of Europe. It's none because this is their basic approach, that they believe that government direction is the right way to go. And so all the innovation and all the great business startups and all the fat, happy consumers are someplace else.
No, that's absolutely right. Sam, do you have one?
Yeah, mine is like James's, and I kind of feel bad because I had already decided I wanted to say this, and I'm just repeating a similar point. But let me frame it in another way, because I think there are lots of elements to this ambiguity. When we talk about unfair self-preferencing, which is what the Senate bill, the House bill was literally impossible, right? The House bill would literally just break the internet tomorrow, because it would mean basically any combination of inputs or products or anything like that would be illegal. I mean, you would really be talking about going back to a pre-1995 version of the internet. The Senate bill is a lot more, on the surface, a lot more reasonably written, because it's much more vague, it's much more ambiguous. But what it lacks in specificity, it has in punishment, which is this 15% fine of total US revenues for anything that is deemed to be unfair self-preferencing that you can't justify in very, very ambiguous ways. Now, that's one cost, because it means that a lot of businesses will basically decide it's not worth bothering. Even if they decide that they want to keep existing products, and I think they will, in fact, change a lot of them, why on earth would they bother A/B testing and taking the risk that something that hasn't yet been proven, that might be good for consumers and might be good for their profit margins, but it's totally unclear, and we know that it could be challenged by a regulator or by the FTC as being unfair self-preferencing. And that gets you to what's really, really concerning, because in a good way, only the FTC and the DOJ can bring, and state attorney generals can take cases under this. So that eliminates a lot of the private actions that might exist. But still having those powers invested in those authorities mean that those those agencies have an enormous amount of discretionary power, because almost anything they could bring, or they might decide to bring to a court, could easily be found against the company. And what that results in is, to quote Jay-Z, this "am I under arrest or should I guess some more?" Well, you was doing 55 and a 54 kind of situation, where the FTC or the DOJ can use the threat of a lawsuit for conduct that is probably okay by most people's standards, but might run afoul of the law as it's written, to exact other concessions from the companies that they want. And we know that the FTC is run by somebody who believes that antitrust should not be focused on economics. We know that the FTC is run by at least two commissioners who think that the FTC should pursue broad social goals to do with dispersing economic power, to do with things to do with race, and things to do with the class system in the US. We know that the FTC is run by people who do believe that antitrust should have this sort of wide social reordering kind of goal. And giving them these kinds of powers gives them the tools, even if it's not explicit, that they would need to do those things. So even if you agree with those ends, I think I'm a little bit concerned about an organization like the FTC being the ones to try to pursue them. So I think particularly for Republicans, and this is a kind of thing for 2022 to kind of look forward, Republicans should question whether giving this amount of discretionary power to the FTC, when it's run by people who are basically their enemies, is a wise decision. And for the rest of us, we should question whether making lots and lots and lots of business practices that are very good de facto illegal, if an agency run by the federal government wants to challenge them, is a good idea. In my opinion, in both cases, the answer is no.
I'm going to try to end this on a happy note, knowing that there might not be one. But I'll raise a question to all four of you writ large. Is there a case for optimism in the future of antitrust law and competition policy? Is there a silver lining that we're not looking at with regards to what this could all look like legislatively in 2022?
I can go first on that. Yeah, if we can dodge kind of the current bullet or set of bullets, if you will, there is some serious thinking going on about how can we improve antitrust, because we know the economic analyses, there are gaps, there are things we don't do very well. And so we want to improve those. We know that some of the case law has faltered lately, and we have ideas about how we can improve that. So we can do a much better job. We're just going to need the opportunity to do that.
And then I guess we can go straight into closing statements. Sam, let's start with you, just kind of tying up what you hope for 2022 and just anything else you'd like to comment on before we close.
Well, the one constant in our lives is political sclerosis, and that usually is a bad thing, but sometimes that can be a good thing. And the optimist in me thinks that this is a very unusual moment where there's a quite unrelated concerns about big tech on different sides of the political divide. And it may be that for one reason or another, the kind of unholy alliance between the Josh Hawleys and Ted Cruz's of this world on one side, and the Cicilines and Amy Klobuchar's of this world on the other side, falls apart for one reason or another. So that's why I'm optimistic that something might not happen. But I think really what I'm optimistic about is the fact that the tech sector is very innovative, and the tech sector is very productive and dynamic. And so the things that I'm really optimistic about are the things that the tech sector brings and creates. And my hope is just that it can continue to move more quickly and innovate more rapidly than legislators can kind of stamp out their innovative activities.
Tom, I'm going to throw it to you. Is there anything you'd like to close your statements with saying?
Yeah, I mean, I think the optimism, Sam talked about the unholy alliance. I think that the grassroots conservative movement is sort of waking up to this real threat. ATR, we've led a coalition of over 30 groups on both the national and state level in opposition to these bills. And, conservatives understand that we've got legitimate anger over some of the things that big tech does, but we understand this is a power grab for the Biden administration in the left. And I think conservatives are really starting to look at these from a conservative perspective, and that gives us cause for optimism.
James, I'll go to you next.
Sure, I'll keep it short. For me, I'm a techno optimist at heart. I think that we have a bright future ahead working on competition and innovation policy at the state level. I know that there are a lot of state legislators that are interested and looking for ways to spur competition and innovation through supportive legislation rather than just trying to take a hammer to it all. So I'm looking forward to the opportunity to work with state legislators and members of Congress, I don't care who they are, to go and advance that goal, because I do think that we can unleash more innovation and competition by pursuing things that can do that in a more effective way than trying to take a sledgehammer to antitrust law, which has been responsible for generating so much wealth and prosperity in this country that we are the most innovative and most prosperous nation on the planet right now. That's in large part because we have institutions that are set up to support that. And I want to go and work with people to go and figure out how we can go and bolster that in productive manners.
And then I guess, Mark, do you want to close us out with your final thoughts?
Sure. I'm just really optimistic about the entrepreneurial spirit and the creativity of the people that I encounter. Most members of my family either are driving businesses or are thinking about they might create one and then pondering what that would look like for them in the future. And then a lot of my former students are just doing amazing things in the technology space or more traditional industries. It's really impressive what people are capable of. They just need the liberty to do it.
No, thank you so much for this. Ended on a much more optimistic note than these bills really are just legislatively horrible. I wanted to thank all of the panelists for joining us. This has been really fun to moderate, and I really hope they had fun as well. But also to thank all of the attendees. This is our last event for 2021 and our last event in our antitrust event series. And I don't think it could have gone better. So thank you, everybody, for this.
Well, thank you. It was a pleasure.
Awesome. Well, happy holidays, happy New Year. And I guess we'll see everybody later in 2021, or if not, in 2022.